Richard Norrie is none other than Fareed Ali, attorney at law. And during the hours of 5 to 6, we have our special guest in the person of Ralph Maraj, political analyst, playwright, former Minister of Foreign Affairs, and the topic will be the Caribbean Court of Justice. And during the 6 to 7 hour, we have the topic of child marriages with a host, with guest Umar Abdullah, head of the Islamic Front. And later on, we are hoping to have with us also Leila Ramdeen, chair of the Catholic Commission for Social Justice on Child Marriages. So, I'm seeing everybody online. Everybody's online and on time. Good afternoon, Fareed. Good afternoon, Richard. How are you guys doing?
Good afternoon, David. How are you? You good? All is well?
Yes, just a bit cool.
Good afternoon, Richard.
Yeah, how are you going? I cool, Fareed. How are you?
I'm good. Good to see you. All is well? How was your week?
Well, what I could say.
Richard, I think your volume is a bit low. I don't know if it's on my end or if it's I'm hearing David.
I think I need him to turn up the volume as much as he can.
Yeah.
No, you hearing me any better there? I'm a maximum.
Yeah. All right, that sounds a little better. Yeah.
Yeah.
Yeah. Politically, up and down. You know, what we could say. The remark by the opposition leader with the name that has been dominating the discussions, you know, about I don't know. What was your reaction to that, Fareed? I said a lot on it yesterday.
Mm-hmm.
Well, so much has been said there. Yesterday, I believe the morning breakfast show dealt with it thoroughly, and then I was listening to you and Mrs. Teixeira. So, well, my position is, you know, like everything else, the politicians, they find ways to get on each other's nerves. They tend to want to rattle each other. I felt that on both sides, the comments made by Camille Robinson Regis and the Prime Minister ought to have been kept out of the public space. There's so many ways of looking at what Camille had said if I were to adopt the Christian name. One school of thought was that she was merely referring to the ex-prime minister's name in referring to Sushala. And then, but there's another view that, you know, the frequency with which it was used and in the tone and the delivery and the diction that, you know, it was geared to provoke. And the ex-prime minister seemed to have taken the bait and then went the full distance in responding. I don't think we should allow them to dominate our minds. That disturbs the narrative of so many more newsworthy things that have been happening of late. This, like every 9-day wonder, this may not last 9 hours, although it crossed certain fronts already. You're asking my view. I felt it was foolishness in terms of so many things are happening in nationally right now. We have so many issues to address our minds to on a day-to-day basis. And if I may put it this way, these two characters come and disturb the rhythm of everybody's week with foolishness. I've heard.
What I could say, that's fair. But the problem is, when these people speak, most radio talk show programs, television talk show programs, their programs are often based on the utterances of people who holding high office in this country. That includes everyone in parliament, including senators, and outside of that, the ministers as well, higher office in that regard. And that's what, you know, unless there's a school fighting, like I'm sure we could touch on some of that later on, as that one was, or natural disaster, or international politics, a shocker to the world, like when Donald Trump was elected. You know, those are the things you're going to find that going to occupy our attention. So that it is reasonable for this matter to occupy our attention yesterday, day before, today, next week, week after, and we'll go all the way into the elections. I can tell you, as I sit right here, that will become the issue to some people as more important than any other issue. And not that the people want that to be the most important issue, you know. Not the people of the country, you know. The politicians, who are the ones who will be directing the meetings, who will be the feature speakers in the meetings. They're the ones who will be driving it home. You could
do you think
brace yourself
sometimes these
here.
comments, do you think that sometimes, I'm just being the devil's advocate here, do you think that sometimes these things are construed and planned? I'm not saying that the two parties colluded to distract, you know. I'm saying that, do you think that sometimes it may be one of the parties? Let's separate ourselves from this incident, or even we could parallel it. Sometimes I wonder if they start throwing all these red herrings to distract the public who's ready, like chickens in a yard to run and pick up the pea. Sometimes I wonder if that is the motive and the agenda, because we have so many serious issues presenting itself. We're trying to recover economically, socially from so much within the past 2 years. And then these little foolish comments come and they're thrown into the public space, and the entire population becomes distracted away from, you know, the trade union issue with regard to the failure of the government to address increases in salary commensurate with the windfall that they just got. So people no longer thinking about that. They're thinking about, you know, look what Kamla say. Look what happened between Camila and Kamla. Because I've been listening, I've listened to the morning shows, our show here, the equivalent, the morning breakfast show. I've listened to the equivalent of this show earlier in the week, and then so many things are being said in the media, on the radio, in newsprint. But the narrative now shift away from the economic issue and shift away from the public servants who not getting the due, to focus on something like this. I'm not saying that this is nothing. I'm just saying that I believe the politicians are so construed in the things that they do, knowing that the audience they're playing to, that they sometimes they throw these things into the public space and distract everybody, and they do it, and we are so gullible to fall prey to it. And when I say we, I'm referring to the public. But Richard, I was thinking of something. In keeping with the topic that we'll be discussing later today, which is the CCJ issue. I was trying to get my mind around just some background information, so when Mr. Maraj presents himself, you and I will be better equipped to deal with him. So in reflecting, I tend to look at, I was telling David in previous weeks, I like to look at local authors and books released by different people. I went to Normandy in the earlier times of this week, and I saw a book by the West Indian lawyer by Keith Sobiel. It was a narrative, an autobiography, or it's more biography done by his son on his father. But let's just shift a bit to our point. And David, maybe you could assist us. You would have your own memory to carry on this issue. Mm-hmm. Do you remember, David, when the NAR had won the election in '86? They were ushered out of government in December 1991, the 16th of December 1991. Mm-hmm. And what happened simply was Patrick Manning, and he had put together a team of politicians, a team of his own would-be cabinet, so to speak, persons to try to see what can be done to get the PNM back into power. So this would have been happening particularly so, and it would have been effectively in action sometime around 1990, 1991. Mm-hmm. So building into that election in December 1991, we had a team of Keith Rowley, Ken Valley, Keith Sobian, mm-hmm. Russell Huggins, Gordon Draper. These would-be politicians, aspiring towards regaining office. So by the time we got into the PNM won the election in December 1991, an Attorney General was appointed. The Attorney General being Keith Sobian.
Yes.
And at that time, if you remember correctly, and maybe you could jog my memory too, but the Keith Tobin wasn't the front runner in everyone's mind to be the Attorney General. He was just around 40 years old. He was a partner in Celia and Company, a popular law firm.
Yeah.
And it was being banded that why would he leave active practice where he, a lucrative practice with a recognized law firm, one of the foremost firms in Trinidad and Tobago, to get into the politics. And on top of all that, we had a situation where Patrick Manning went on to appoint him as Attorney General at age 40.
Yes.
Now, if we look at the term in office, the PNM had gotten into power in December 1991, and Manning had called an early election in 1995. So he had called an election in 4 years, sorry. So an election which he eventually lost, but that 4-year period, and this is where I'm getting, Richard, that 4-year period was a very eventful 4 years. In that 4 years, we had the Oka Sipol incident where the Speaker of the House was placed under house arrest in Port of Spain.
Yeah.
In that same time frame, we had a situation where Brian Lara had scored he had broken the world record, the 365, and that then administration had given him the piece of land on Chancellor Hill. And we also had the Glen Ashby hanging.
Yes.
If you remember correctly,
Yeah.
we hadn't hung anybody in this country
Since.
for many, many years. And so this is where I'm zeroing our thoughts, Richard. If you remember correctly, Ashby was hung around 6:30 in July 1994, if I recall correctly. And 2 weeks before Ashby's death, there was a murder in Westmoreland where 2 women lost their lives. This was the popular Chuck Atting murder. Chuck Atting was later charged for the murder together with someone else, a minor. And so what engaged the minds of Trinbagonians is that we had murder being on a spiraling rise, if we may put it that way. And the PNM's reaction was to do something out of the ordinary. They had hung Glen Ashby, and thereafter, it was said that for 6 weeks after Ashby was hung, there wasn't a murder in Trinidad. For 6 consecutive weeks.
Yeah.
The country was quiet. Criminality had come to a halt. Not one murder in 6 weeks following the hanging of Glen Ashby. And when I'm reflecting with my mind's eye. The criminality in this country is of such right now, where it's an 18% detection rate. The fluorescence of gangs, I don't want to say it's on the rise, but a lot of the numbers are going up. And when we compare the number of murders in Trinidad and Tobago to what it was last year, I mean, there's no comparison. We already crossed the 200 mark.
I tell you.
And we've completed 5 months of the year. Now, people like to do parallel statistics and cross-reference to other countries. And we love to bandy the name of Jamaica into the narrative. I often say that, given Jamaica's population size, that narrative of comparing Jamaica to us is an unfair one, because they already, according to their statistics, 11% or 4% higher than they were in this comparative quarter. For the year, Jamaica has already had 500 plus murders within 5 months. But bear in mind that last year, their total was 1,400. What I'm saying, Richard, and this is where we are. We've had a Prime Minister, Mr. Rowley, who's been talking about the issue of granting bail to persons who are charged before the court for murder is not where Trinidad wants to be, and it's not what the population wants. This was being bandied into the public space even when the Court of Appeal, their decision was pending as it relates to Akili Charles, which is the person who raised an issue as it relates to his right to bail, given the fact that, murder accused in this country are denied bail under Section 5 of the Bail Act. Now, Akili Charles, sorry, he's merely the the subject of the discussion in the context of just a name. What he's representative of is hundreds of murder accused who are remanded in custody, not getting access to bail. And let us make this projection. When the Court of Appeal made its decision that Section 5.1, which is the Section 5.1 of Act number 18 of the Bail Act 1994, the Court of Appeal, with Justice Archie sitting, indicated that the prohibitive clause, which is Section 5, subsection 1 of the Bail Act, that clause was deemed unconstitutional, and that the clause basically speaks to the fact that one cannot be considered for bail for the offense of murder cannot be considered. It's a prohibitive clause. So the Court of Appeal ruled that that prohibitive clause, David, is unconstitutional, and it's not in keeping with one's constitutional right to bail. So let's put everything in context. Where we are right now is the Court of Appeal decided upon removing a prohibitive clause that denies persons bail when they charge for murder. It means to say in reality that our judiciary has made a decision to allow applications of bail to be heard for persons charged for murder. One has to ask the question whether there's a correlationship between the rise in criminality and the fact that now would-be offenders, persons who might be inclined to commit offenses of murder and unlawful killings of any kind, feel a certain amount of space, a certain amount of room, margin for error. If they feel a certain amount of freedom now, that they don't have the heavy hand of the law weighing upon them, that they can do as they want, that the prospect of bail is around the corner. I'm marrying that to the narrative of 1994, just when Ashby was hung. Persons didn't feel that because at that time, in that context, the right to the law, as it speaks to hanging persons who are before the court or who have been found guilty, was very active, and the PNM chose to, and I'm purely saying the PNM because they were in government and it happened under their tenure. They choose to enforce that law. What is your position, Richard? Do you think that we should resume hangings, or you're in two minds about it?
Yes. No hesitation. I think we should start back hanging. There's no two ways about that for me and my consideration. Thou shalt not kill. That's scripture, right?
But let's forget the scripture.
Family. You could kill in defense of your family because the laws in this country and of England, the majority was derived to us from that place. And theirs is based on their Anglican belief, and so on. So therefore, our laws here were also based on a sort of a Christian or Christianity philosophy. And you can't leave it out. Even when you go to natural justice in court, it flows from that place. So I am saying, yes, I support hanging. Why kill people because you believe you could murder someone, plot to do it, conspire to do it, and then carry it out, and then go to before the court to beg to spare your life? Law, if someone puts you under duress and tell you kill another person, as they will deal with some other person or something that some of your belongings they love so much in a particular way, it doesn't give you the right to kill another person. That is the one time you can't use duress. You know that? You could use it in other instances.
Does it give the state the right to act in a similar fashion?
How is that?
All right, my position is
carrying out the law. The state is carrying out the law. If you are found guilty of murder, and then you appeal, and that appeal is upheld, and then you go to the mercy committee and everything form a straight line, and let us assume in 5 years, but the ruling the other day says, hey, it's the parliament Forget a 5-year arrangement. You know that we discussed that here. The Parliament is where that could be addressed and any other such matter. But hanging is still the law. Once it is on the books, I support it. If tomorrow the wisdom of the people in Parliament, who were elected by the people, decide to change it, whether I agree with it or not, if the law then is it's no longer part of our justice system, I'd say okay, you can hang because that's what the law says. So I'm supporting it once it's a law.
Right.
And I'm saying do all you could to carry it out once someone qualifies for it. Yes, carry it out.
So this is where we are. This is where we are. And we will hold Mr. Maraj to account for this when it is he presents himself at 5. But
yeah. What's Mr. Maraj saying? What you heard from him?
No, well, we will deal with him here where we are. This is the backdrop to when we corner Mr. Maraj at 5 o'clock. If we look at the laws of Trinidad and Tobago, the Constitution, and I have it before me here, right? The Constitution of Trinidad and Tobago speaks to our rights under Section 4. Section 4 has some basic positions, 11 scribe rights that we have, right? And if I may just allude to it, it is said here, and I'm quoting, it is hereby recognized and declared that in Trinidad and Tobago, they have existed and shall continue to exist without rights of discrimination by reason of race, origin, color, religion, or sex. The following. And this is the first one. A, the right of the individual to life, liberty, security of person, enjoyment of property, and the right not to be deprived thereof except by due process of law. May I say, Richard, that the right to life, liberty, security of person, and enjoyment of property, it is extended to criminals also. But let's move on. Right? The right of the second part, the right of the individual to equality before the law and protection of the law. That equality before the law and the protection of the law, Richard, that also applies to persons, criminals, persons behind bars, persons who was charged for murder. Now you notice it's two separate things. They didn't incorporate one into the next. It's a separate law. It's a separate right, sorry. Let's look at the third one, the right of an individual to respect for his private and family life. When you put a man behind bars...
You broke up. Could you do over 1 and 2 before you go to 3?
All right, no problem.
Yeah.
The Constitution talks about rights, and there are 11 rights ascribed in that Constitution under Section 4. The first one speaks to the right of an individual to life, liberty, security of person, enjoyment of property. And the right not to be deprived of that except by due process of law, right? So that exists. Right. And I'm saying that exists also for the criminal population, the men out there who committing crimes, who depriving people of their life.
Right there. Except by due process of law. Except by due process of law. Which is to say, you could be denied those things after due process of law, and if it says something else. Right there.
Richard, due process of law continues when you're remanded at the prison also. You see, when it says you're in remand and you're waiting for a high court trial in 10 years, due process of law.
The process is ongoing.
Right, good. Yeah. So let's look at the second part, B, the right of an individual to equality before the law and protection of the law. So a separate right, equality before the law and protection of the law. So even when you're locked up behind bars, you ought to be treated in no different way from Richard Norrie or Farid Ali or David McIntyre, no different way. You ought to be treated, you have the same protection of the law that we have in the free world while you're locked up.
Yeah.
And we may even go so far to examine the rest. You also have the right of freedom of thought, freedom of expression, freedom of movement. Now, bear this in mind. All of this talk about we switching from the Privy Council, meaning that we're removing them as the highest appellate court, and we're going to, there's an agenda now among the politicians. There's an agenda raised by the independent senator, Mr. Vieira. There's an agenda where we have an attorney general speaking about we should get out of this colonial mentality where we're seeking assistance and guidance from law lords in England who are not in touch with our culture, who are not in touch with our values, who are not in touch with the ethos on the ground in the Caribbean. We should move away from that and embrace the CCJ. The CCJ, they are the they have both original jurisdiction and appellate jurisdiction, meaning that issues as it relates to granting bail for persons remanded for murder have been treated before the CCJ. And the CCJ, in the case of Boyce in Barbados, years ago, they ruled that in interpreting the Constitution, and this is where we were, that's why I read those rights there, that one must not be bogged down by a savings clause that alludes to the penalty for murder is death, and the issue of persons who commit crimes that the sentence may be, they may have to pay with their own life. The CCJ is saying that we need to evolve ourselves beyond those rigid laws and interpret human rights in a manner that is consistent with the changing values and the current values and current ethos that we live in terms of the global ethos. Now let me put that in a different way. When we adopted the constitution that we did, the 1976 Republican Constitution of Trinidad and Tobago, we have enshrined in our constitution certain laws that were saved. And one of these saved laws was Section 4 of the Offences Against the Person Act 1925. And that section speaks to the penalty for murder, or those found convicted of murder, is death. That savings clause is what the laws, the Privy Council alluded to when it is they ruled in the case of Chandler recently in the Privy Council. They alluded to the fact that that save law that we have here, that our legislature has taken no opportunity to remove, our executive, the government that is the incumbent government, they have not addressed that savings clause. They have the power to remove the savings clause. They have the power to adjust legislation to have that amended, and it was not done. Now, the CCJ, in making its ruling in a case, and I want to quote the case, I don't like to just say these things and it comes across as if I know what I'm talking about. The case of Quincy McEwan, Sion Clark, a 2017 matter. What the CCJ did is they said that that savings clause, right, must be taken in the context of it was a colonial law, it was a colonial adaptation that Caribbean countries, when they gained their independence, they saved that into their laws and they applied. Now, Belize was the only country in our jurisdiction. What they did is they put a 5-year moratorium on their savings law. So when their constitution came into being, they put a timeline, like a sunset clause on their savings law. So for the first 5 years, these old laws, these colonial laws, they remained on the books, and then they would have expired, and it would have given their maturing constitution enough time to evolve and adapt, and laws to be made and formed to suit their own culture. So Belize was a step ahead of us, if we would put it that way. A lot of Caribbean countries, we have enshrined these old laws, and let us put it in another context. Remember Watson Duke, when he was charged for sedition, and when we looked at the law, was a law almost 100 years ago that they invoked in order to charge him and say what he said amount to seditious. It was threatening to the state, threatening to the incumbent government, threatening to do harm to public officials and so on, and he was charged. So everybody kick a big fuss and noise, and all these constitutional theorists and commentators come out and say, but how we could still have this on the books? But they wouldn't talk about how we could still have the penalty for murder being dead still on the books. They're happy with that because somehow that touches a nerve within them that they could live with. But they couldn't deal with an outspoken Watson Duke. So they had mixed opinions as to whether the sedition law should have remained and shouldn't have. I'm just using that as an example. So yeah. I could say that sedition law and all, that and all only on the books because we in Trinidad and Tobago saved these things into existence when our constitution came into being in 1976, the Republican one. We ain't go back and put a sunset clause on the old existing savings law. We allow it to be. So that clause turning around to bite us. If it is we move towards removing the Privy Council has a history of recognizing the existence of the death penalty. They did that. They said, listen, the savings law that you have, that prevents forming any law or creating any law or interpreting any law in a context of not applying the death penalty. They simply said that the death penalty will be upheld, right? Because that savings clause that you all have there, that has no sunset clause on it, has no expiry date. It doesn't have a subsistence time frame. That stays there, and because of that, the court has the right to sentence persons to death until your executive, your legislature, and in this country, the executive being the government and the legislature being the same public officials who sits in parliament and bring bills forward and suggest bills and have bills passed into being with the support or non-support of the opposition. They're basically creating law, but they're not touching that savings clause. And in all fairness to them, it's not just the sedition aspect and it's not just the death penalty issue. There are other laws that we have seen that are very archaic, that are still on the books. Do you know that under the Immigration Act, Section 8, that immigration officer could debar imbeciles, bankrupts, homosexuals from entering this country? So if it is you're coming through and you're a self-professed homosexual, on the basis of that, you could be denied and turned back and sent back to wherever you came from, because our law says, Section 8 of the Immigration Act, that we don't allow persons like that here. Now, I'm just alluding, I'm using examples. I am not of the view, and I'm not arguing a case for keeping the Privy Council as the highest appellate court. I'm simply saying, I wonder if in the public space, all the information is being provided to the public, because the CCJ, they have had a history of interpreting the constitutions of various Caribbean countries and its signatories in such a way that allows for a liberal interpretation of the law. Let me use the example, the Makion case that I mentioned. This was a Guyanese case. It originated out of the jurisdiction of Guyana. What happened is there was a law, Section 153, subsection 1, and Roman numeral 60 plus. But what it says is this, and allow me to quote it, right? That section prohibits every person who, being a man in any public way or public place for any improper purpose, appears in female attire, or being a woman in any public way or public place for any improper motive or purpose, appears in male attire. Now that law, Richard, that was on the books in Guyana pre-independence. It's an old law. Now what happened is a group of cross-dressers, whatever their agenda, that is the choice that they make. They dress and carry themselves in a particular way. Men dress like women. They were arrested. And when they were arrested in February of 2000, they were put in jail for some 3 days. And then when they weren't told why it is they were arrested, they simply was of the view that is because of the way they were dressed. The police were harassing them. It was in the wee hours of the morning. And the Society Against Sexual Orientation Discrimination, SASOD, they took particular interest in this particular case. They went before the magistrate, and the magistrate took umbrage in terms of saying something to them, and he told them that they need Jesus and they should turn away from the life that they're living. And grown men dressed like women, and why they're on the streets, that or one, so on. That was the Guyanese position. However, in making the ruling, and this is where I am, right? I don't want to stray too much. In the ruling, they were awarded damages for not just unlawful arrest, but the fact that the police in arresting them didn't fully explain to them why it is they were being arrested. So they weren't told that it's because of the way they were dressed and how they were looking, and they were cross-dressers and so on. When they were sentenced under this law for being dressed in female attire and not having a proper purpose in doing so. The CCJ ruled, and this is where we are, the CCJ ruled that was discrimination against the persons, and that in any modern democracy where we have respect for one's human rights, where we have respect for a person's freedom of choice, where we have respect for a man's right to life and liberty and enjoyment of property and so on, that no no democracy would accept that sort of treatment being handed out to its citizens. So the CCJ is saying that saving, they didn't allude, the judges at the CCJ, at the appellate level when they were ruling, Justice Saunders didn't look at the fact that we have a savings clause, and to dress for male to dress in female attire not having a proper purpose is a criminal offense. He didn't look at it that way. He was saying whatever the existing savings clause, whatever law existed, that the savings clause preserved that law. So he is saying that savings clause saved the police from being accused of improper motive when they arrested these cross-dressers. And that the application of the law 153 of the Summary Jurisdiction Offences Act in Ghana was a correct application. And we have in one instance where the local court saying that, oh, it's good law, just like you saying it's good law, a man commit a murder, it's good law to take his life, hang him. The same way you saying that your volume off, you have to take your volume, put on your volume, Richard.
After due process, yes.
Yeah, the same way you saying that, oh, the law exists where we ought to apply the law as it is, meaning the penalty for murder is death. The same way the Guyanese jurisdiction, the Guyanese court was saying, well, the law as it relates to men dressing improperly without any, in female attire without any proper motive, exists on the books. That the police were correct in arresting them and charging them. But the CCJ ruled that we should look beyond the savings clause that preserves that old law, that we should interpret law in the context of what is the rights of individuals enshrined in the Guyanese constitution, the right to happiness. It speaks to the right to happiness, the right to life, the right to enjoyment of property, the right of freedom of expression, of freedom of movement. And these rights, the spirit of the application of these rights, the appellate court said, why interfere with them? They didn't bring any harm to anybody else by their actions. They didn't compromise the integrity of anything in the public space. So they were there not bringing harm to persons, harm to any individual.
What was the mischief? What was the mischief the saving clause was placed there for? What was it trying to prevent?
Well, let me put it this way. The saving clause was preserving a law that was couched in an era, some 100 years plus, that was pre-colonial, and it was trying to prevent men from dressing in a lewd manner that offended the general public. But what we are saying is that the judge is saying that the fashion taste has changed so much. He's not even going down the line of the orientation of the men. We're not dealing with the sexual orientation because that is not an issue.
We're talking about attire.
They're talking about attire. He's saying that fashion has changed so much that what was on the books 100 years ago that men should not be dressed in female attire, he's saying we can't particularly distinguish between what is male attire and female attire anymore, because fashion trends have changed so much that what a man would have been wearing when this was on the books may not be what a man would wear now, meaning that he might dress more, let me put it this way, in raw language, he might be dressing in something that might be more associated with what women would wear. We have unisex clothing now. But what I'm saying, Richard, and this is where we are, you are saying that if the law is on the books, the law should be applied until the law is not on the books. The CCJ is saying the law could be on the books, but when we interpret the Constitution in the context of the law at the time that the law was created, then that wide interpretation of an expansive interpretation, and using the word mischief, the mischief that they are addressing is the issue of in modern times, these people who dress in a certain way, and I'm just alluding to that particular fact before we move forward, that shouldn't be used against them. If we were to use the Watson Duke situation, the language that he used, that law was scribed in a colonial time when the Crown was trying to protect its limited public officials who were simply outscored in terms of population numbers in the Caribbean, to protect them from any vigilante population who want to take the law into their own hands. So they can't just speak out against the public officials and say things or seditious things or threatening things about them and their property. So it's to keep them in line. Once the law is there and you apply the law, people know to behave themselves. I am saying, and this is where we are with regard to the CCJ, I have no issue in a very academic way. I have no issue with the shift away from the Privy Council to the CCJ. If it is we are doing it with the correct motive in mind. I have no issue if it is we are of the view that the value system and the ethos of Caribbean people, that the CCJ and the Caribbean Court of Justice and the judges sitting there would be more familiar with how we feel about ourselves politically, economically, socially, and they could make decisions that are consistent with our interests. But what I'm saying is, if it is the general public out there believe that the Privy Council is out of touch with our reality, so much so that they apply the law in a way that might be consistent with what we want or our needs, we might be in for a rude surprise with the CCJ, because that Mark E1 decision and the wide interpretation, they ain't let themselves be bound down by any savings clause. They said that our old law and that savings clause, we prepare to get beyond that. And our preparation would take us that
well,
no
I guess they were
existing...
looking in that interpretation, I guess they were trying to look at applicability to the existing acceptance and where we are in the way in which people dress, what you may call now the modern society. So they probably decided, well, perhaps this now has to be applied to a modern society. When this was up is when the society operated this way. So it was applicable to that society. The society today is very different to the society back then. So they probably decided, well, then we cannot apply the interpretation here to a society that no longer exists. We now have to apply it to the existing society. And if the existing society will not take umbrage for it, then how we could say that they will be offending people if the people are not offended by it? So probably that's what they try. But I will go on to say, though, if that is still, in my opinion, not for judges to do, though, I think that required going back to the parliament for the law to be amended. So when I say the law had to be on the books, I want to go with what the law on the book says. And if the law on the book says X, I want to go with X. If the society no longer wants X, let people vote in a way so that when they put people in parliament, they'll make the adjustment for them. But until that adjustment is done, the law on the books will be the law.
All right, so this is where we are. Our position is that in the Caribbean, 9 out of 14 Caribbean states don't have anybody sitting on death row waiting to be hung. 9 out of it. That is 9 out of 14. And I'm not just saying that. This is the narrative I'm seeing in the Trinidad Express, Friday, the 27th of May, 2022, an article by Erica Guevara Rosas. It is said, and I want to quote here, that in the Caribbean, the resort to the death penalty has been on the wane. 2 countries have been known to have imposed death sentences in the past 5 years, Ghana and Trinidad and Tobago, while 9 out of 14 Caribbean countries with the death penalty have had empty death rows for several years. However, legislative steps have been long overdue. Now, my concern is this. If it is we're in a position where we would like to adopt the CCJ, the Caribbean Court of Justice, as our final court of appeal, we need to understand this. Trinidad and Tobago are signatories to various treaties around the world. And in England, the death penalty was abolished since 1966. There is pressure, Richard, from around the world on Trinidad and Tobago to adopt positions that are synonymous with the settled international practice standards. Remember, and I'm alluding again, right? You remember when the age of majority, a female could only consent to sexual activity if she acquires the age of 18. You remember that?
Yeah.
Sorry, it was the age of 16, and then it was raised to the age of 18. So right. the position is that we adopted that position. That was international pressure. The United Nations and UNESCO and so on, and the various organizations, they were saying to us, we can't have this archaic law in our books. So we adjusted and we raised the age of majority from 16 to 18. of course, that got us in some heat with the religious organizations here, and that's a topic for a different day. But we've been known to adjust and cope with international pressure. If it is the death penalty is being abolished, and it has been abolished in 4 African countries already. It has been abolished in England. It's being abolished around the world. So that glee that you may have that you take a life and therefore and I'm just being provocative with you that one should hang.
It's alive and kicking in Singapore. They killed 2 persons just the other day. You know this, right?
Yeah. Richard,
they tried to save them. Yeah, they tried to save them. They say, yes, Mr. Maraj, welcome. When he puts on his camera, we'd welcome him well. But they tried to save 2 of them the other day in Singapore. They say one had an abnormality of the mind. He grew up, although he's an adult. He could never think straight, and he didn't do well in school.
Yeah.
You remember that? You know that case?
Yes, I remember that.
So they dealt with that and those guys, 2 of them. So when you say there are some countries that hold fast the law of death by hanging for murder, and mind you, they didn't kill anybody. Yeah? They were hung. You know for what?
What exactly?
Because they carry, just like in China, you cannot carry illegal drugs into Singapore or China. The penalty for that is death.
Trini might try it anyhow.
Who?
Trini.
Trini might try it?
Well, you can try it anyhow.
Well, I wish that Trini luck. That's the last Trini might hear from me, because those countries not like ours, China did it to a person who had a stick a joint in them. Google it and see. Right? A British guy. And he probably didn't even remember he had it in his suitcase, but the system picked it up. And they asked him for his own. He said, yes, for personal use. They said, well, no, come across here. You in a different category. They arrested him and handcuffed him, all kind of thing. And you want to know what's going on? They said, no, in China law is, once you bring that kind of thing into our country, you're going to be tried immediately. And if you're found guilty, the punishment is death. That's the consequence. He sent out to England and the ball and made all kind of noise. England and they say, hold on, hand, we're trying to get people there. They told them, you got to get them here today, because this is where China law would prevail. And they weren't able to reach in time, my recollection, that was a few years ago. And that was it to the guy. They got the international community to tell China, hold your hand. China said to the world, you all are the mouse that roared in China. China is king. And they went ahead with their operation. So while we talk about whether we should hang someone for murdering someone else, look at the standard they use in Singapore and China. And their argument was, it is to get, especially in China, 10% of their population hooked on them thing. What, as they said, what their health bill going to be like? Who funded that? That's why China, they say no.
China can't be the standard bearer for international human rights. They're the last, or one of the last.
Well, we know they're very barbaric. We know that. Yes, it's true. But let's go to Singapore.
We can't use that.
Let's go to Singapore. Singapore is not China. They may resemble the Chinese people, but they ain't. But their law is the same in that regard.
Yeah.
Yeah.
I don't know if David could assist us in terms of getting Mr. Maraj on. I'm seeing him there. I wouldn't like to have him waiting indefinitely. I know his time would be precious, and what we have to discuss with him is touching and concerning what we're talking about, so we could incorporate him seamlessly.
Are you hearing me? Are you hearing me?
Yes, we are hearing you. We are hearing you, Mr.
We're hearing you loud and clear. We're not seeing you.
Oh, you're not seeing me. Okay. Start video. Let me see if it. Are you hearing me now? Are you seeing me?
Oh, we see part of you, Mr. Maraj.
All right. All right. Well, I hope. Let me see. Start video.
You're flashing us. We're seeing you, and then you're okay. We're seeing you now.
Yeah,
so what are you doing? Hold it there. Hold it there. We're seeing you.
All right.
Yeah.
Okay.
Okay. We want to welcome you, Mr. Maraj. Thank you for making yourself available and for being so prompt. you're on time, and
I hope I'm not too early.
No, not at all. We're hoping to maximize and monopolize your time for the time that you're with us.
Yeah.
We're just we're having a discussion, and today we are discussing the Caribbean Court of Justice.
Yeah.
We know that you have strong views, and like every citizen, and you've served on both sides of the political divide, and you've held public office, and you're a notable and noteworthy commentator on national issues. So we're hoping to get some frank discussion from you with regard to your position. If I may be permitted to say, where we are is this. There is Independent Senator Mr. Vieira brought a private motion, and he was indicating that, you know, we should finally adopt the Caribbean Court of Justice as our highest appellate court. Yeah. And remove the Privy Council altogether. Now, this narrative has been back and forth for some time. As way back as 1986, Patrick Manning then said that we ain't ready for that, in his language. Then in 2012, I believe, the People's Partnership, they were promoting the adoption or embracing the CCJ as the highest court of appeal. 10 years after, in 2022, now we are heading into almost 2023. The narrative have changed from the People's Partnership, and the current Attorney General is stating that we should embrace the Caribbean Court of Justice because they are more in tune with our values, with our ethos, with the spirit of the Caribbean people. We've seen, and if it is we were to address our minds to the Privy Council, we've seen where they've made some very strong, they've taken strong positions in the past. In cases where, and I want to allude to that before I bring you in, I'm saying that if we examine the role of the Privy Council, a lot of persons are of the view that, you know, they wouldn't be swayed by political old talk, they wouldn't be swayed by social norms, they wouldn't be swayed by or be influenced by any particular sector or interest group, because they simply, Lord Huffman, who sat for 9 years and who has been sitting now, he said he has never even made it to the Caribbean, and he has been ruling for 9 years on Caribbean issues. So that in itself speaks to the fact that, you know, he doesn't even understand what it is to land in a Caribbean country and experience Caribbean life, but yet still he's making decisions. So people want to use that sometimes in the narrative against him. But if we allude to some cases, and I'm just throwing this into the public space, I'm sure we'll get a response from you thereafter. The Mahasabah for many years and the Islamic Relief Center had piloted matters before the High Court of Trinidad and Tobago and the Court of Appeal, where they were seeking licenses to carry their own radio programs, and they were denied that. It's only at the Privy Council level, it was the Privy Council ruled that was discriminatory. And thereafter, the Mahasabah and so on were able to get license to have carry their own radio programs. That was in one instance. When we look at other topical issues, the issue of the Trinity Cross, both at the High Court and the Court of Appeal, our local courts upheld the fact that the Trinity Cross ought to be treated as the highest national award. And the Hindu and the Islamic element, their position was that, you know, that is essentially a Christian symbol, and they had issue with that it should be something more neutral. It's only at the Privy Council level we were able to address that issue. Our local courts couldn't deal with it. So there are live examples in the public space where issues like this required a neutral mind. One final example is when we look at the appointment of members of the Judicial and Legal Services Commission. For many years, there were judges being allowed to sit on that commission, and it was the Privy Council rule that you ought not to have judges sitting on such a commission. And then, so we are seeing live examples of where the Privy Council did things that were in keeping with independence and in keeping with making decisions that local courts was not making. Now, let me make one final comment before we bring you into the foray. Within recent times, the Privy Council upheld the issue of the penalty for murder being death. And in other words, the death penalty was recognized and upheld at a Privy Council ruling. And they made the comment that the savings clause that exists in Trinidad and Tobago, which is Section 6 of our Constitution, allowed for certain laws that predated the efflorescence of our 1976 and 1962 and 1976 Constitution. It allowed for the saving of those laws. So Section 4 of the Offences Against the Person Act 1925, that remains on a book which says that the penalty for murder is death. That remains on our books because of the existence of that savings clause. When the Privy Council ruled recently in the Chandler matter, they had upheld that they see no reason why they can tweak the law in any other way, because it's clear your savings clause, Section 6, says the penalty for death is murder. So therefore, we have to uphold that position. It is not one of those instances where the law could be interpreted in any other way. Now, when we look at the Caribbean Court of Justice, in Barbados, the penalty for murder is death, and it's now bailable as of 2019 April. Our local courts have only just addressed that issue of bail, removing the prohibitive clause for bail for murder, and allowing persons who are in remand for murder to access bail if it's necessary, or if it is the court sees it as they being worthy candidates. So this is where we are, Mr. Maraj. What is your position as it relates to the substitution of the Privy Council with the Caribbean Court of Justice? Do you think are you of the view that the Privy Council are not in touch with our realities?
Well, first of all, let me thank you very much for having me on your show. And I was enjoying your banter, the both of you, on the previous thing about the death penalty very much. And I want to congratulate you. I think you are Farid.
Yes, please.
Yes.
Yes, I am.
I want to congratulate you on your exposition just now of the dilemma that we face as a nation seeking to either accept or reject the Caribbean Court of Justice as our final court of appeal. And of course, if we accept the Caribbean Court of Justice as our final court of appeal, it means that we will have to discard our allegiance and our adherence to the Privy Council in London. Now, as far as I'm concerned, having the final court of appeal in your country, within your jurisdiction, and emanating from your society, your culture, and so on, is the ideal. That is the ideal. And as a young politician myself, when I started off in the 1990s, when I first became elected to the parliament and entered the cabinet, I shared that ideal that the Caribbean Court of Justice should be the final court of appeal for Trinidad and Tobago and other CARICOM nations. However, as time passed by, as one gathered experiences, and as one's eyes opened to certain realities, some of which you highlighted just now in the cases that you pointed out. As one saw these realities, you began to wonder whether that was in the best interest of Trinidad and Tobago. And that, for me, is the position I hold right now. I am no longer sure that we should leave the Privy Council and adopt the Caribbean Court of Justice. Because, CARICOM, first of all, it is not a nation. It is subject to all kinds of disunity. I think, for example, they haven't taken a unified position about attending the Summit of the Americas. That's just one example. They have been, infamous, CARICOM, for not implementing decisions We have had a decision to establish the CARICOM single market and the economy for over 2 decades now. And when A.N.R. Robinson was the Prime Minister, that has not yet been achieved, in spite of the very best efforts of a number of people. So that is CARICOM subject to the kind of unity that can produce justice that is required of a Caribbean Court of Appeal? Is insularity still prevalent in CARICOM, where all kinds of prejudices against one another, one nation against the other, and so on, reign as it had reigned at one time in the selection of the West Indies cricket team? Do we have that still? What about the state of what would happen to minorities in the CARICOM arrangement, in the CARICOM population? Will they be afforded the same kind of voice and influence in an atmosphere where justice must be impartial and impartially delivered? CARICOM countries are small countries, small nations, heavily politicized. Every Caribbean nation has a vibrant political life, with political parties and political loyalties and so on. Fortunately, a lot of these countries, the loyalties of the population is not based on ethnicity, race, and religion, and so on. Fortunately, but still, many prejudices abound. Will these prejudices influence judgments in the CARICOM countries? And those are just some of the things that are in my own mind at this point in time, and makes me wonder whether CARICOM is itself ready for to house and to accommodate and to impart justice as a final court of appeal for the citizens of the CARICOM country. So I have my doubts at this point in time, and I would want to hear more discussion on it. I would want to be more convinced. For example, already in Trinidad and Tobago, at present, you have questions being raised about the delivery of justice. The Prime Minister himself has spoken about the delays in the delivery of justice and so on. All kinds of inefficiencies have emerged. And this Chief Justice himself, questions were raised about his conduct, about misbehavior, and three appeal court judges and an independent judge as well said that there should be a tribunal. A tribunal should be held to investigate these allegations. The Prime Minister didn't heed it. He didn't yield to it. And one suspected the reasons he gave, to my mind and in the mind of others, reeked of political positions, as it were. So you don't know. You have a lot of doubt being created, and this is the reason for my own position of being doubtful about the Caribbean Court of Justice as the final court of appeal for Trinidad.
But Mr. Maraj, the sentiments that you have shared are legitimate. But those sentiments are echoed around the world. If it is, we look at how the judges are selected. It's a regional judicial and legal services commission that selects the judges. It's not any provincial body in the context of, let us say, it's populated by persons from a particular island. If we look at the CCJ president right now is Justice Adrian Saunders. He's from St. Vincent. When I look at the narrative, Justice Witt, he's from the Netherlands. Justice Winston Charles Anderson is a Jamaican. Madam Justice Maureen Rajnath, she's Trinidadian. That's just the composition. The Regional Judicial and Legal Services Commission makes that decision, and these appointments are made across the board. It's a fairly balanced scale of persons and judges are arriving out of different Caribbean countries. If we look at the selection process, in the UK, it is said that they have their Judicial and Legal Services Commission that appoints their judges. Those judges are appointed into positions at their level, and they can retire at the age of 70. In the US, it's a politician, it's the president who has the say in terms of appointing judges, and we saw with Mr. Trump, he packed the bench with conservative judges, and their tenure on the bench is for life. They can stay there until their demise. If we look at what we have in place here in the Caribbean Court of Justice, there's a retirement age of 72 with an option to have one retired at 75. So there are checks and balances in place within the Caribbean Court of Justice that allows for not just the tenure of persons, but for a mixed forum of qualified practitioners selected by a recognized Judicial and Legal Services Board. It's not an individual choosing a person. This is not a situation where you have Kamla sending up, a particular individual where it could be deemed, well, he owes his position to her. The committee meets and makes a decision, and the decision, as a result of it being a committee decision, tends to carry the air of it being a balanced position. So in as much as I share what you say, we've had the CCJ in existence since 2001, dealing with matters of not just original jurisdiction, but appellate. So we've had them under observation for 20 years. This is not we, Trinidad and Tobago, attempting to embark or adopt a course that has not been followed before us. We've been observing the ship of state. We've been observing the CCJ and deliberating on matters for 20 years. So we've had ample time to determine whether they have the capacity to be balanced, the capacity to be biased, and the capacity to carry the torch in the manner that we expect of them. I think, so in as much as I share what you share, or your view, we have to be open-minded enough to consider that there is empirical data out there that speaks to the fact they've demonstrated if they need to be independent, they can be independent, and I don't think we can point to, unless you can show us in your experience a notion where you figure, well, they may have been acting in a manner that is geared, that could be interpreted as carrying a bias.
So far, no. But as you say, we must be open-minded, and I am prepared to be open-minded. I am prepared to be persuaded. I am not persuaded fully. I am not. I think it is the ideal. It's an ideal I would like to see, but I have become disenchanted with what we have aspired to as a Caribbean civilization. Our own civilization in Trinidad and Tobago is, in my mind, deteriorating rapidly. It is fading away. The standards that we had in the past are no more. We have racial tensions and biases prevalent in this country. Political biases influencing so many kinds of decisions, all kinds of decisions in this country. You wonder what is taking place. Is that being replicated throughout the Caribbean? So one has an open mind. You're right to say that we have had the Caribbean Court of Justice in operation for 20 years. But if the truth be told, let's be frank, it has been in the background of our minds. It hasn't been in the forefront at all. And what has been the portfolio? I mean, any outstanding cases? I mean, I know the CARICOM itself goes there for rulings on trade matters and things like that. I have not heard of any outstanding case, so I may not recollect, but I can't recall right now any outstanding case that where it has demonstrated the impartiality, which I am sure it may have this impartiality. But as I say, it is we have to be persuaded, and I think a significant percentage of the population of Trinidad and Tobago, I dare say, I think that a lot of them remain unpersuaded. And they need to be persuaded. The kinds of things that you are saying will help, and this kind of discussion will help people to think about it. And so maybe we should really put it to the people. I think the suggestion has been made about a referendum. We should really put it to the people.
Mark was saying we should have a referendum of 75% of the people supporting it. And then, you know, then we should adopt. But Wade Mark tends to be one of those, when he was in government, Mark was supporting the CCJ. Suddenly he wants a referendum of 75% now that he's out of government. So people suspicious of his motives. Now, I want to be provocative when it comes to you, because you're one of those unique persons.
Farid, hold on. Yeah. Let me move on to a couple of things that Mr. Maraj expressed a short while ago. First of all, I want to agree with him fully that when he says he's not persuaded to take a side either way, I know a tremendous amount of people who share that view in this country. And just like him, with all honesty, when we heard about it at the beginning of the discussions before it was actually established, I think most of us felt it was a good idea to cut away from the Privy Council and let us have our own final court of appeal, because we would understand ourselves better as Caribbean people, and we'd be able to take better decisions, you know, our peers assessing ourselves and judging ourselves. But for the same concerns that Mr. Maraj raised a short while ago, those concerns changed over the last 20 years. Today in Trinidad and Tobago isn't as it used to be 20 years ago. And you have a tremendous amount of concerns that are huge enough to be factored into the equation to help anyone arrive at a determination as to whether or not we should have the court as the final court of appeal. I share the view fully that since we have two lanes of justice or the legal system in the country, which is the criminal lane and the civil lane, for me, I've reached a place where I think we could use the Caribbean Court of Justice as the final court of appeal for civil matters, but not criminal matters. Because based on the types of concerns people have in this country, and I don't think I could capture it as well as Mr. Maraj just did, for those very concerns he raised, those things when someone's freedom is at stake, you don't want to have to consider that. You'd always feel that however that decision played out, it may not have been based on the strength of the case, on the strength of the legal presentation, and the proper interpretation of the law by the judges. You would feel something else was at play. And when it comes to justice, you don't want anyone walking away feeling that they were undone or whatever for some other reason other than what was before the court. So I am saying I am for civil matters, final court of appeal, CCJ. Criminal matters, Privy Council. Why? Because where the Privy Council is concerned, whatever you say about them, the British people and so on, it is however they rule and they sit down and preside over a matter, they do so for all of us in the Caribbean. In that, when I say so, they don't know you, they don't know me, they don't know any of us. And therefore, the main thing they would focus on is what is the issue before them and the facts in relation to that issue. And that is what they're going to take a decision on. They don't know us. So that they will believe when they're taking a decision, it's the best decision they could arrive at based on the strength of the case that has been argued before them. Finally,
Mr. Richard, but our Prime Minister...
Let me say, can I comment on what Richard just said there?
Yes, of course.
I think I fully, I like what he said. I mean, it is so, and very well put. Very, very well put. I have myself have thought that, we argue that the Privy Council is not here. But isn't the distance between the cultural, if you want to call it the cultural distance, the distance from the social norms and expectations and habits and so on, isn't that an advantage in the dispensing of justice? The other thing that came to my mind when Richard was talking was that, we talk about, our sovereignty is incomplete when we do not have the CCJ as our final court of appeal. But what we've got to remember is that sovereignty requires responsibility. Sovereignty means maturity. How mature have we become as CARICOM? Are we mature at all? Is CARICOM mature enough to recognize the realities and the need to have a single market and the economy, which is really for which the CCJ was established as an instrument? And Richard talked about freedom and democracy. That is at the heart of our society. That is at the heart of our society. Democracy is critical. And without freedom, you have no democracy. Of course, freedom within the law. Freedom within the law. So I think these are critical issues. And I like the suggestion that maybe we could really, as a start, to give it the higher profile, if you wish, in the CARICOM, in the Caribbean, make it the final court of appeal in civil matters. I just wanted to make that
Gentlemen,
yeah. But hold on, Faris, I wanted to say one more thing. I wanted to say one more thing that Mr. Ralph touched on. 1 second. He said that the Caribbean court, he couldn't recall of any high-profile case, and he's right. But there was one I just want to put on the table that was a bit high-profile. I think the entire Caribbean was looking at it, and that was the Guyana's matter in relation to the elections. You remember that?
Yes,
so
I remember that.
So I think that is as high-profile
a matter.
Yes.
That's a good one. That's a good one.
Yeah. I think they did a good job there, and I'll call that even along the line of the civil side. You see, no one's freedom was at stake, per se, in terms of incarceration. So the Caribbean embraced the decision. You realize that? So I am saying it's a good court to give us the pride we want in the Caribbean, to say that we could manage our own affairs and so on. It's a nice starting platform to say, before we get into the criminal lane, let's test our own ability over our own selves on the civil side. And I think they started pretty good there. And we should continue to pursue that if we possibly can.
Well, you're suggesting a very novel position, because we can't, you can't embrace them halfway, Richard. You can't get them half a hug. You can't say we're going to just take you on board to deal with appellate civil matters and we're leaving you out of the criminal matters. It's either you embrace them at an appellate level.
Why can't you do that, Farid?
There is nothing in place for that approach, that hybrid approach.
Well, we can put something in place.
Of course, Mr. Maraj is right. The reason we are discussing it now is to put it on the table for it to be considered. What we could do thereafter is to see how it could work, what we need to put in place for it to work.
Yeah. I mean, and it is a new court. Law is always evolving. Yeah. The courts are evolving.
20 years is still new.
Right? CARICOM is itself. CARICOM is itself still evolving. CARICOM is very good in terms of intra-CARICOM trade. Right? It is very good. It works very well. Trinidad and Tobago benefits from intra-CARICOM trade, the free markets access to the markets and so on. But there are other things that need. You know how we collapsed as a federation. You've heard that story, haven't you?
Yeah.
Political cohesion has always been a monumental task, a monumental obstacle for CARICOM integration.
Dominica, Belize, Guyana, and Barbados have fully embraced the appellate jurisdiction on all levels. There has been no suggestion before. I don't want to say suggestion before now, but I can't speak to that. But there's been no overture made before to embrace, to adopt that position where we're going to deal with them with regard to civil matters as opposed to criminal. But let me say this. We have an Attorney General, Mr. Amor, Senior Counsel. We have a Prime Minister and an independent senator who are pushing hard with regard to this adoption of the CCJ as the highest court of appeal. They are saying their argument is that only there's a commentary that only the wicked and the wealthy can access the Privy Council. And I would imagine they're saying the wealthy because that speaks for itself. If you could afford to pilot a matter that far and get a British Queen's Counsel to argue your case, then once you could pay his fees, then you're okay. With regard to the wicked, I believe what they simply mean is that when it comes to matters involving somebody's life, the law lords, they approach the fees and the fee structure is different because we're dealing with a human life and life or death situations. So the persons who appeal at the Privy Council level and it's their neck is at stake, there's no charge involved. So I guess that's where the wicked comment came in. But what our AG, PM, and independent senator is stating, Mr. Maraj, is that access to justice is cheaper if it is for the common man on the street. It will be cost effective. More people would want to challenge matters, and justice will might very well be greater served if it is we have the Caribbean Court of Justice as our highest appellate court. People may feel that it's more accessible, not only geographically, but in terms of affordability, in terms of our pocket, that we are wasting foreign currency on something that, or we may not be wasting it, we may simply can't afford the currency in order to access that justice. So if it is we were to hold on to the Privy Council, it might be at an expense that we may not be able to bear. And a lot of people may allow things to slide, meaning that they don't challenge certain things because they can't afford to challenge it. So we may find that if it is we adopt the CCJ now, it would hasten and quicken the wheels of justice rather than slow it down.
Well, that might be a good argument for a good argument. I mean, the starting point for in a discussion. But if it indeed is an impediment to accessing the Privy Council and getting final justice and so on, then there has to be some other thing that a humanized society would do to ensure all of its people have access to this justice. You don't want, because of the expense, to have an imperfect situation where you are dealing with justice, because you're dealing with people's freedom, you're dealing with people's lives, you're dealing with people's very existence. And you need to think about this very carefully before you take any action. That's all I would have to say on that.
And I wouldn't really want to support either, based on the PM's argument that Faris is saying that is being made, a senator and the Attorney General, that we could have a situation where people could have access to justice, but then there's a huge question mark surrounding the quality of the justice.
Exactly.
So it comes down to the quality. So for me, I don't know if we could come up with a different system. If we want to incorporate the Caribbean Court of Justice overall, if it's so, people see it as such a significant thing for us to do so it could go down in the books as an accomplishment for us in this country in the Caribbean, then let's incorporate it as best as we could. But that may not necessarily mean the removal of the Privy Council. Couldn't we extend, Fariza, Mr. Maraj, the levels of appellate court? We could say, okay, we have the Court of Appeal. Perhaps we could remove that and put the CCJ there and then leave the Privy Council over it. Some people may be satisfied at the CCJ level on some matters and decide not to go all the way to the Privy Council, but it should be there as an option for who wants to utilize it.
Yeah, something has to be done. That's the point I was trying to make, Richard, that something has to be done if cost is an impediment, because, you know, money should not, or lack of money should not deny anybody the access to a perfect system of justice. As you said, because we don't have the money, employ an imperfect system of justice where, you know, justice is not really imparted.
And therefore, miscarriages of justice will be very high. The probability of producing such outcomes will be high.
Yeah.
And that's not what you want.
That's right. That's right. So, there you have it, Farid.
I was reading recently, Mr. Maraj, where Dr. Indira Rampasad, she recently said, she was addressing the Sir Arthur Lewis Institute of Social and Economic Studies. She said that there's a great paradox in the Caribbean. CARICOM, and I'm quoting here, CARICOM has within it a huge sovereign paradox. They want a regional integration scheme, but they're not willing to surrender any sovereignty. So basically what she seems to be stating is that in the Caribbean, we're pushing for a CSME and open borders where we could have professionals and qualified persons from various Caribbean islands taking up employment within each other's country, meaning cross-border streams of labor. We want free trade. We want to remove all these hindrances to being able to trade freely, remove all these stamp duties that may impede the flow of goods and services through and between each other. In other words, to generate wealth and to boost our economies, to support each other. But while we want to embrace that free trade, we're not on the same foothold with regard to embracing the highest court of appeal. We divided on a position with regard to CCJ, so it's almost we have one foot on one side and the next foot on the other, and that divided position is not going to help in terms of moving forward and growing as a region. So, in as much as you all are arguing the position, and when I say you all, Richard and you seem to be on the same page, I'm not against. I'm seeing what you're saying, but my mindset is we don't want to be sitting in this position and having this argument with different personalities, meaning somebody's carrying the same discussion we're carrying 20 years from now, but we're no longer in the picture. At some point in time, we have to make this step, and we have to be bold enough to make big decisions. And big decision is going to lead to progress. It's like your Prime Minister stated.
That position that Ms. Rampasad articulated is very much related to what I said at the very start. CARICOM is not a nation. It is not a nation. It pretends to be, and it is a conclusion I have come to, it pretends to be, or it aspires to be, an integrated unit. But even on the economic front, as you very rightly pointed out, we may have free trade, but we do not even have free movement of labor. Only certain categories of workers can move within the CARICOM region, because people have problems with this free movement of skills in the CARICOM. Now, I don't know if they have changed it recently, but that was what had pertained for a number of years. So we are not a nation. The federation, or major attempt at political unity, the federation collapsed on us because of all kinds of insularity, which continues to this very day. So,
Mr. Maraj, I want to provoke you, right? Yeah. I want to provoke you. We are meeting virtually, so you can't physically throw anything at me, so I can take the chance to provoke you. You are speaking from the position of a concerned citizen, as a commentator, as a learned mind. So you have that independence that you can exercise in your current capacity. you've sat on both sides of the political divide. You have inner knowledge of how these decisions are made. I'm not asking you to comment on your dispensation in terms of on either side of the political divide, but I'm asking you to, I'm trying to draw on your experience. Why do politicians and why have the politicians been blowing hot and cold with regard to embracing the CCJ? And I'm asking you that specifically in terms of when you sat on either side of that divide. Why it is there were times when sometimes they support and sometimes they don't support. Why wasn't that decision made so many years ago? Why are we now dealing with this 20 years after the existence of the CCJ?
Because I think when people are in government, they aspire to the ideal and they take certain decisions that may look good or sound good. But when the task comes to implement, they get into the nitty-gritty of things and they face certain realities. Moreover, when they are in opposition, when they go into opposition, they take a different position from when they are in government. That has happened in Trinidad and Tobago. And you know what we're talking about. Because certain realities emerge. And what has been happening. So that's why I'm saying, if you are talking sovereignty, you're talking responsibility, you're talking about a mature society with a mature politics, and you're talking about a society that is moving towards an enlightened position. And I am afraid we are nowhere near that.
Are you of the view that
Farid, can I answer that one? I want to see it as what I will call political pettiness. To put it simplistically, political pettiness. Why? When a party is in office, they want to peddle the concept and the idea of, we should have the Caribbean Court of Appeal, it would be this great thing for all of us and so on. The party in opposition are sharing that position because they're saying, if I support you inside to get that, that is too much of a landmark achievement for you to get that you could use for decades to come in the political arena in this country. So once you're outside, you're not supporting it. But as soon as you get in, you say, no, I now understand why we should do it. It's a good idea. Why don't we implement it? Because you see, history would show it was under this leader or that leader that signed off when it was established. And that will be there in permanent form for many years. And I'm calling it political pettiness because even if I was a political leader and I'm in opposition, but I could see the value of it for the country and the Caribbean, the bigger picture, it doesn't matter that the person inside will get that moment and decades to come as the person and party that did it. My focus would be that it was for the greater good. Mm-hmm. But how many
Richard, it will be, in light of what you're saying, it will be very, very nice. And it will be an indication to me that here's political maturity. To have someone in government, right? Whether it be this PNM government or any other future government, UNC government, NTA government, whatever. Somebody to articulate these concerns, which are legitimate concerns and which are rife in the population at large, people's concerns and people's doubts, and bring it to the people of Trinidad and Tobago. Articulate it. Let's have a national discussion on it. But so far, nothing like that.
Yeah, and that will be helpful. That will be very helpful to positioning us to take a more informed decision. Because by having those conversations, everybody would understand what they need to understand so that when you are taking a decision, it will encapsulate so much more than it may right now if you were to take it without those conversations.
I agree. Really.
There are laws that are, Mr. Maraj, there are laws that have been in existence before so many Caribbean countries became independent. So when Trinidad and Tobago acquired its independence in 1962, and even when we adopted the Republican Constitution in 1976, there were laws that predated, that came out of the colonial era. Richard and I were speaking earlier before you came on with regard to, let's say, if we look at the laws on sedition, the Sedition Act pre-existed, that ordinance pre-existed our independence. That remains on our books today. Laws as it relates to the preservation of the penalty for murder being death, that pre-existed the formation of the 1962 and the 1976 Constitution. Now, my position is this: when it is we adopted our constitutions and we formed these constitutions in 62 and 76 in Trinidad and Tobago, there was savings clause that preserved some of the laws that existed before, and hence we have laws on our books now that are archaic. Are you of the view, and I'm giving you an example with regard to sedition, I'm giving you another example with regard to the penalty for murder being death by hanging, are you of the view that some of these laws ought to be adjusted? Because the Caribbean Court of Justice in other jurisdictions that have adopted it as the appellate court, they have been addressing these issues, addressing the issues of the savings clause, of the colonial laws that are still on the books in the Caribbean islands. So in that regard, the CCJ has demonstrated that they're prepared to push the envelope, they're prepared to take stance and assume positions that the Privy Council have been very, very hesitant to walk. Are you of the view that, based on that example I'm giving you, that the Privy Council is falling short of the vision of the CCJ in that regard? To me, the CCJ, in my view, the CCJ has gone further than the Privy Council in addressing archaic laws and in getting behind those saving clauses that hamper Caribbean countries from exercising justice along certain lines.
Well, I was surprised that with the case you cited involving the Court of Appeal and the death penalty, because as far as I am concerned, it is the Privy Council's attitude towards the death penalty, as revealed in the Pratt and Morgan case, that has been an impediment to the exercise of the death penalty in Trinidad and Tobago. Now, I think you've lost me. You're right. I think, let me just say very plainly. From what I gather, I've been on radio, I'm talking to people and so on. From what I gather, the majority or a significant percentage of Trinidad and Tobago, citizens of Trinidad and Tobago, favor the death penalty. They want people hanged, right? There's a minority, and here's where I agree with the Privy Council, and I agree with the removal, the amending of that law. There are some of us who think the death penalty is archaic, and there ought to be other forms of punishment. And for all of the reasons that have been cited, unfair punishment, cruel and inhumane incarceration, wrong decision making, all that kind of thing. So I am with respect to the death penalty, I would like to see that removed and amended so that we do not have the death penalty in Trinidad and Tobago as the law. That is my minority position. I am aware that certain politicians do not agree with the death penalty, but it is something that you can't bring to Trinidad and Tobago, to the population of Trinidad and Tobago, as a politician. You can't, because the majority of people will think you're mad, right? And they think they want a death penalty. But I am saying a sign of an unenlightened society is the fact that you want this death penalty as the final for murder. Now, murder takes place for many reasons. The other thing is you quoted the sedition law. Yes, it is colonial. Yes, it has to be amended, because under that law, from what I remember, and I had to use it several times in my articles over the last couple of years. With that law, a dictatorial government, can imprison me or you or Richard here for talking on the radio things that they don't like to hear. And that is bad, because that colonial law came into being in order to empower the colonial authorities to fight against any demonstrations and so on that were taking place in the colonies at that time. So I think that has to go. That has to be amended. But it is very interesting that governments don't want to touch that at all, because if you touch that, you give up some of the power that you have as a government, as a prime minister, as a minister of national security, and so on.
The Henry polls had indicated that there's a 12% public confidence in our local courts and in our justice system here locally. Now these polls, of course, they're based on certain parameters and so on. I'm merely quoting it because that is the figure, that is the information that is peddled in the public space. When they conducted the polls about public confidence in the justice system in Trinidad and Tobago, because of it takes 20 years sometimes for a matter to be decided upon before the court. I guess that would be more so in criminal matters. The public confidence is just as low as 12%. That may present itself along the lines of, it lends itself to the view that people might not trust our local jurisprudence. They may not trust our courts to deliberate in a matter that is in keeping with the needs of the people. Do you think that there's a general sense of apathy and anarchy? And when I say anarchy, what I mean is people are not comfortable with the dispensation of justice locally, and that...
Absolutely. I share that view. I absolutely share that view. And the question we must ask is, what has been done under this Chief Justice to improve that delivery of justice? He has been there for some time, and I think he will be there for quite some more time. What has been done? Even the Prime Minister recently talked about all of the things that the government has done and so on, and put in place, but nothing has happened, virtually. That's what he's saying.
Allow me to defend my Chief Justice.
Yeah. Go right.
My position is the government has a responsibility, the executive has a responsibility to allocate monies to develop courts, physical courts, throughout the length and breadth of the country. So we need more courts. You cannot expect a limited number of judges operating out of a limited number of infrastructure, meaning buildings, to dispense justice at a faster rate when it is you have criminality growing faster than you have access to the justice. So let me put it another way. The rate with which criminality takes place on a daily basis, violent crime, minor crime, serious crime in this country, our judicial system can't cope with that sort of efflorescence. More criminality there's crime taking place on a daily basis, and our courts are already overwhelmed in dealing with matters that are before it from yesterday. So it's up to the state.
From yesterday.
Right. It's up to the state to increase the number of courts. It's up to the mandate to increase the number of judges to be exercised. Yeah. And when that is done, if you're telling me that we have increased the number of courts, magisterial and high court levels. Right now we have 2 courts, three, San Fernando, Port of Spain, and Tobago. We have about 11 magistrates courts. We have not increased those numbers. What we've done is if we've cried on the judiciary that they need to work faster, but yet still hundreds of people are added to the remand list, added to the court list in terms of the charge for offenses.
Yeah, I agree with the level of criminality, creating more and more problems for the justice system. I have talked endlessly about what I call the spreading swampland of social decay that we need to arrest in Trinidad and Tobago, and from which springs the criminality, from which springs it. And the government needs to do something about that. They need to set up a social and cultural regeneration program. And that is something takes a long time for it to bear the kind of fruit that we want for a civilized society. That's why I keep saying our civilization in Trinidad and Tobago is receding. It was already thin. We took it to a certain extent after independence, but after that, it started receding over and over.
I agree with you, but I agree with you, but we can't blame the judicial system.
No. I am not blaming you. No, hold on. I am saying I agree with you. I agree with you. This swampland of social decay is throwing up so much crime. Even the commissioner of police, acting commissioner, said it here. Very simply, he said, we're not dealing with the social ills. And governments after governments have come, and they have not dealt with it. Youth hooliganism, child abuse, domestic violence, right? Murder is only one aspect of it. So what needs to be done for us to have this maturity that we are talking about that comes with sovereignty, this enlightenment that comes with sovereignty? What we need to have is a government understanding the need to arrest this decay through a deliberate intervention. You just can't come and say you're going to do this and do that and do it piecemeal here and there. It has to be a deliberate, comprehensive intervention. That's why I have said to the Prime Minister and the Cabinet over and over, set up a special Cabinet subcommittee chaired possibly by the Prime Minister himself. This thing is so important. But by the Prime Minister, made up of the Minister of Education, Culture, Attorney General, National Security, Social Development, Sport and Youth Affairs, and so on. And with the technocracy and other interest groups, come up with a plan for national regeneration and social and cultural regeneration. That I have listed among three very important things, the three most important: arresting that social decay, economic modernization, and institutional dysfunctionality, which of course, where the judiciary is at the top of the list. So you are right in saying that the society is throwing up too much crime, but recommendations have been made. You talk about the courts, and I agree that we need more courts. Ramesh Lawrence Maraj, for example, former Attorney General, has suggested over and over that we can have these temporary courts. You do not need a building. You do not need buildings for this to take place, so that you can have a sort of rescue mission, a rescue program. And he has outlined a number of things that could be done. Sadly, it was done about 3 years. That recommendation came about 3 years ago. It hasn't happened. So, it has to, the plan, the solution has to be done in a holistic way. The whole of government approach, as it were. And that's how I see it.
So you have the view that we need to deal with our own house and putting our own house in order in Trinidad, in terms of socially, infrastructurally, institutionally, in terms of dealing with our own jurisprudence, before we could even think of embracing the CCJ on the level that the discussion is taking place now at a national level. Because
I am just telling you, my friend, that whilst I, as an idealistic young man, politician coming into the system, I embrace the idea of the Caribbean Court of Appeal as the final court. As experience took over, my eyes have opened to certain realities in the Caribbean and in Trinidad and Tobago. I am now I have significant doubt. I like this discussion with you and Richard. It has helped to open my own eyes in many ways, and you are both very, very good. I want to commend you for the quality of the discourse. Very, very good, gentlemen. Thank you all very much. It was a real good pleasure, great pleasure being with you, and I want to wish you all the best as we go forward. I'm talking like because I see 6 o'clock is upon us.
Well, we want to thank you for making yourself available.
Yeah.
Yes, Richard?
Thank you so much, Mr. Maraj. It was a pleasure doing this part of the show with you. And you have brought a lot to the table that I'm certain we will take away from it today. I like your positions on the issue, and I think they are quite solid. And as we move forward, I believe more of the country would lean towards that type of position. So thank you so much.
Thank you. You're welcome, my friend. You're welcome.
Okay.
Enjoy the rest of the evening.
Thank you very much, Farid. Thank you. Thank you very much.
Farid, our next guest is here. Not so?
Umar
Yes.
Abdullah, I'm seeing he
Yeah.
he's on the cusp of joining us. Mr. Abdullah, you have to turn your volume on. You're off. We're seeing you, but we're not hearing you. Put on your volume.
Right. Sorry about that. My mic was muted. All right. Yes.
Good afternoon, Mr. Abdullah.
Nice of you all to have me this evening on this very, very controversial topic. I don't know. I'm surprised that this is a discussion that is still happening, though.
Well, it's relevant. It's relevant. But before we get into the discussion, we want to thank you for making yourself available. Richard, I have to confess that Umar is not just a guest, but he's my very good friend. We well acquainted with each other. Right? So but it was coincidental.
Well, Richard and I are friends as well.
Yes. we are friends.
Yeah. So where we are, if I may address you, Mr. Abdullah, is there is so much put in the public space with regard to the age of majority, if we were put it that way. Richard and I were talking earlier, we were addressing each other along the lines of, if we were to examine the issue of child marriage, there were social norms that invited, if I may put it this way, that allowed certain religious organizations to embrace child marriages. But those social norms would have been dictated by time and place and circumstance. Times have changed. And if we may put it this way, let me be political. Between 1956 and 1986, we had 30 years of our PNM administration that would have had on their books or would have allowed, through the laws that they were enforcing and the laws that existed in our land, for persons of a certain age to marry. So the Hindu position would have been acknowledged, the Islamic position would have been acknowledged, and you had persons under the age of 18 enter into marriages. As time would have changed politically and so on and socially, we would have evolved out of that position, meaning allowing young ladies and young men who haven't acquired that age of majority, meaning the age of 18, to marry. Now, there's a social context to some of these marriages. You would have had situations where, because of religious positions, the Hindu would have had a position in relation to allowing certain young women to marry. The Muslims would have had a different position or similar context. As time evolved, within recent times, we've seen within the last, I believe it was 2016, if I'm correct. Richard, you could correct me if I'm wrong. Just around 2016 is when we had that change in the law where the age of majority, meaning the age one can consent, the law recognizes one to be able to consent to sexual activity, raised from 16 to 18. So
it could have been between 2016 and 17, somewhere there.
Yeah. Now, as a result, Umar, this is where you're coming in. As a result of that change, where the age of majority, as we say in law, the age of majority recognizes 18 as the age of one can consent to that sort of sexual activity. We had the fluorescence of the argument that these marriages that took place with persons under the age of 18 now, that ought not to be allowed, because that in itself is a violation of a child's right to being a child. Now, we all know that we live in a society where situations and circumstances, politically, socially, that determines our legal position. Sometimes the laws are a reflection of the social norms. That change from the age of majority from 16 to 18 would have been influenced by the United Nations and various treaties that we would have signed in order to be in line with the international settled practice and settled standards. We had to adjust our laws to suit. What is your view, Umar? What is your view in terms of recognizing that the age of majority shift from 16 to 18? What is your view in terms of, do you think that was a good position to take, or do you think it was a backward step?
But first of all, let me just indicate at this point here that I would have been one of those who was vehemently opposed to the changing of that law. Not necessarily for the same reasons why Maraj would have challenged the change of the law. All right. But it was more with respect to preserving the religious doctrines that that surrounded that whole aspect of child marriages and so on.
Yeah.
And when we say child, that term in itself, it's relative to the society in which you live to as well. In our society, yes, we would look at those ages as those individuals being children, of course. We have the law where if you were to have a sexual interaction with a 16-year-old or persons under that age, you have committed an offense, even though that person or that girl would have consented. All right.
Yeah.
We're saying there's no consent, under a particular age, and that might have been one of the arguments put forward in the changing of the law and so on. But saying that, we also have to recognize religiously, as the Hindus would also agree, early marriages are originally recommended. It is healthy and it helps, for chastity and so on. Delay of marriages is very helpful for, to keep away the evil whispers of the Satan in encouraging young people to engage in sexual activity and all of that. When a girl reaches the level of maturity, physically and psychologically, it is recommended for them to marry them off soon as possible. One of the main aims in doing this, of encouraging early marriages, is to preserve the chastity of our youth. That's a very important point. And the other thing is that Almighty God has created human beings with sexual desires, and we all recognize that. And if we look at our very own society, I would have had reports coming in from MTS guards and MTS cleaners at the schools indicating that they would have oftentimes walked into classrooms or onto children having actual sexual intercourse in the classroom and so on. And these children are under the age of 18, some at the age of 14, 13 years, and they're all engaging in this activity. And as such, a boy or girl who reaches puberty and develops sexual organs, the best and very best parents, that's in our view, can do, the very best that a parent can do, is to prepare them for the life of responsibility, which is marriage and so on. We have to also recognize the urge for sex can be very strong, especially in adolescence, and in most cases, it is the urge that in some cases must be satisfied by some. So they are going to find a way to satisfy themselves, and so it will either be a halal way, in our view, or a haram way. Halal meaning marriage, and haram meaning, outside of marriage, you're having, sexual engagements and so on. And you know, in our society we have so many you know, sex toys and all these things that is available, that young people are finding easy access to. And you find the very same, you know, we talk about the rampant premarital sex in secondary schools and even in primary schools, as we have been getting some reports in recent times. And also there's a lot of health risks that is associated with these type of activities and so on. So in order to protect the child, that's the religious position. Now we come to the question of society on a whole and the way society has developed over the ages. And right here in Trinidad and Tobago, you we see it happening, you know, before our very eyes, and we are calling for a lot of changes in our constitution because it no longer is relevant because of the change of dynamics within our society and so on. And what I'm saying is that one has to also recognize that what's the cultural norm in a society and what would be accepted in a society as ours. Now, obviously, when that issue came up, there was two sides of argument, and obviously one side won. The law was changed, and that sort of thing. And I think that side that would have won the argument looked holistically at the general, you know, dynamic of our society as a whole and the way our society has progressed over the years. Now, one thing they have failed to recognize and they have failed to address is the issue of creating a society that would not encourage premarital sexual activity and that sort of thing. Creating safe environments, creating, you know, the type of education that will inform our young people that, you know, a life of, you know, abstinence before marriage is better and that sort of thing. Because in Islam, I could talk about Islam. I think the Hindu religion will have a similar sort of doctrine where the sin of the child after they attain the age of puberty lies on the shoulder of the parent. As long as the parent is unable to control that child and to manage the activity of that child, you know, in doing good and remaining in a pure state and that sort of thing. So those are the kind of you know, issues that obviously is going to come up when this issue of child marriage is coming. So in some societies it's a normal, it's accepted because it's the norm. In other societies like ours and so on, in Western society, it's frowned upon, it's not accepted. And I think nothing is wrong in in going the way of you know, not allowing your child to get married at such an early age and so on, allowing them to go to school, get an education and all of that and so on and so forth. Even in my own household, and my wife and I would have these conversations sometimes and so on concerning our daughters and etc. So all I'm saying is that proper provisions must be put in place. If you take a decision, like for instance, when Kamala Prasad Bisesa, when she was prime minister, and she had you know, banned the corporal punishments in school, there was nothing that was put in place to deal with the fallout of that. And what we had happening after was there was a rampage in the school where students was, you know, beating upon teachers, getting themselves into fights. You know, we see it happening now, and we cannot no longer use corporal punishment to correct these students or correct these children. So we would have failed in putting those mechanisms in place because we wanted to change a law, or we wanted to put something in place that would reflect or represent what our society is. But we have failed to recognize that we also had to put mechanisms in place to prevent such fallout from taking place, right? So basically that's, so my position in a nutshell is you have to recognize the cultural norm in a society in looking at changing the laws. Now, the reason why I would have opposed that change of the law was that I would have preferred to preserve our religious doctrine or religious laws, but also recognize that because of our changing times and the society in which we live, we also had to recognize, we needed to give children that opportunity to live their childhood years and enjoy their childhood years, and to give more time for us to prepare them for a life of marriage, a life of, independency and all of that. And we should have been at the forefront of putting those mechanisms in place, in changing this law, or in accepting that we should, not allow our children to get married at such an early age and so on. So I would have been just cool with, let's not do it, let's not encourage it, but leave the law as it is.
Do you recognize that Trinidad and Tobago, though we have laws, a constitution and laws, and we tend to govern ourselves in the context of the laws that we create and our constitution, which limit the application of those laws, that we have relationships with other countries. We have relationships with the United Nations, we have relationships with the European Union, we have relationships with international agencies. And in order to be a part of these agencies, we sign treaties and we accede to certain treaties. So you have to recognize, and I'm saying this to you, you have to recognize that we have pressure being placed on us from external bodies to align our laws in a particular way. If it is we want to be part of...
Not here.
Umar, you need to unmute your mic, or maybe it's the signal. Are you...
Yeah, no, my mic is unmuted. Yeah, it's a signal.
All right. Right. So what I'm saying is, do you recognize that though there may be some legitimacy or some viability in what you're saying, we are under pressure from international organizations and agencies, and because we are signatories to certain treaties, we have to align our laws in keeping with international practices in order to be part of these relationships. You follow that? Yes?
Yeah.
Right. So in as much as your views may be somewhat avant-garde and they carries some substance, we have to give way sometimes if it is we want to be part of communities, international communities, and benefit from the umbrella of support that they provide us on a day-to-day basis. You see that as necessary, right? That applies to national security, it applies to economic security, it applies to getting aid, it applies to life in general. We need support. But in order to get that support, there are certain things that we need to embrace, which is the best practice and the settled practice and the thing. And this issue as it pertains to the age of majority and children. This is a very sensitive issue, and we have to align our laws, and we have demonstrated that we are prepared to align our laws in order to incorporate ourselves with international settled standards.
Yes, I agree what you're saying, and I quite understand the ramifications of us, especially in relation to our international treaties and so on. What I'm saying is that if a problem does not exist, but then it doesn't affect us. But this is a problem that does definitely affects us, because there has been in our country a lot of instances where children were married off at a very young age, and we still have that practice even within the religious communities, the Hindu community and the Muslim community, and these practices are not actually being reported and that sort of thing. All right. So there are ways in which people circumvent and go around the whole issue and still maintain that sort of status quo within their own circle.
Umar, I share where you're going. I'm saying that when you say ways to get around, there is the law of the land, and the law of the land recognizes that the age of majority is 18. So there's no way to get around. What you're talking about is breaking the law. I accept what you're saying.
I do understand what you're saying, and I'm not encouraging that. I'm not encouraging that. I'm just saying that this is reality. This is what happens.
Right.
You understand what I'm
So,
saying?
in
You
other
know,
words,
yeah. Farid, hold on. I think Mr. Abdullah touched on two things I want to touch on.
yeah,
One, he said that you know, the reason they had it as they did, which I think is a very good reason, was to help young girls, my interpretation from what he said,
yeah,
prevent them from getting into promiscuous relationships and so on. Is that correct, Mr. Abdul?
Yes, yes,
And I
yes.
think that was, yeah, I think that is profound, because you would want to make sure your daughter, you'll want to do anything to prevent your daughter from entering into that type of how should I say, sexual behavior. And from what Mr. Abdullah is saying, by marrying them off earlier, you give them new responsibilities early. Uh, Permanent, if I could say so, alignment with a spouse, which reduces the likelihood of, not that it can happen, but reduces the likelihood of that young lady ending up in such a situation. I get that. But I just want to say, but Mr. Abdullah, carrying it to 18 years of age, it's just a few more years that, we'd have to protect our daughters, to escort them through that period. You think is highly likely the same thing we like to prevent, we couldn't prevent it just for a few more years to 18?
Let me answer that question in this way. When the age that I was speaking about, when this was the norm,
Yeah.
it was never like how our society is today.
Mm-hmm.
All right? That age that I'm talking about, when we grew up, we never had to witness, sexual activity outside of marriage amongst young people at the rate we are seeing it today. We have never
True.
had the internet and young people exposed to pornography, all right, and all the different sorts. As a matter of fact, Trinidad and Tobago, I understand at one point in time, probably still is, the country that has been labeled #1 in the world, accessing pornography and so on. And this is a real concern for religious parents, or parents who want to bring their kids up in a pure fashion. And all I'm saying is that, just as how you said that you're just a couple more years to manage our children, you and I both know how difficult that is. You and I both know how difficult that is. And let us not behave naive at this point in time and believe that our children, our girl children, are not going to find themselves on the other side of the fence. I would have had a personal experience with my own daughter. And this actually happened before the law was actually changed. I had to get my daughter married at the age of 16 because of the issues that existed with my daughter at the time. And it's so difficult in a society as ours to teach our children right and moral conduct, and at the same time manage so many other influences that influence them on a daily basis. When our children goes to school, we are not there to police them. We are not there to manage them. We depend on the school and the security aspects of the mechanism of the school and so on. And even in the schools, as we have been having some reports lately, where cleaners working with the MTS organization, security guards, walking in on classrooms and actually, encountering boy and girl
Umar, I accept.
Not only that, let me finish this point. Boy and boy having sexual relations and girl having sexual relations. This is where our society has become. And all I'm saying
the society has evolved in that direction, Umar. But what is my thing? We can't also solve a problem by creating a different kind of problem. When it is you have young people getting married, at an age when I'm not even using the number 18, but we're using the number 18 is in our minds. That is what is on the table. There are people who are above the age of 18 who are not ready for marriage. They're not emotionally ready. They're not psychologically ready. They're not in a position where they can cope with the demands of a relationship. They don't know about compromise. They don't know about doing all the maturities that are required and the development emotionally, socially, psychologically that is required in order to exist and subsist in a relationship. So when you put these children under the age of 18, perhaps even younger, in a situation where they're now discovering themselves, they're now developing physically, they're developing emotionally, you put a different kind of pressure on them. What you're doing is you're creating an environment for chaos. And I'm saying that in keeping with what you're saying. The society has evolved in a direction where we have young people exposed to sexuality, exposed to pornography, exposed to the media, social media. So they're being taught things at an age now that you and I may not have been exposed to when we were growing up. They become more sexually charged, more sexually sensitive than we may have been when we were their age. But if it is we were to encourage them to marry in order to constrain their desire for sex and their desire for engaging in things that are essentially the design for adulthood. In introducing that, what we're doing is creating a different kind of problem. We may be creating further for domestic violence, bringing a 14 and a 15 and a 16-year-old into a marriage, and they don't know how to resolve a problem. They're going to fight. It's going to reach the physical violence. They're going to disagree. So we may be solving the issue of, you're sanitizing their sexuality or their activity and making it right by lowering the age of majority, allowing them to marry, but then creating a social problem that we don't have the resources to deal with. How do we establish a balance between lowering the age of majority, allowing them to marry at a younger age, right? And then facilitating their emotional and physical development to a level where they can cope with the institution of marriage?
Very good question. Very, very good question. As a matter of fact, I was going to ask the very same question after you were finished. The thing about it is that one of the more important question is, what actually was the genesis or the object change from one age to another? Was it to prevent persons from marrying off their children at an early age, or was it to prevent promiscuity in society and that sort of thing? Because in my view, it didn't do that. It didn't prevent promiscuity in our society. As a matter of fact,
I accept that. We can't legislate morality into being. We cannot raise the age of majority to 18 and then get everyone to comply, meaning the young people are not going to recognize now that now the law is 18, so therefore we ought to restrain ourselves. So I'm agreeing with you in that regard.
So do you agree with me, long before we would even attempt to change the law, in particular this particular law, that we should have gone, we should have been having public consultation on the issue, engaging all the different institutions that would have been responsible for, for teaching this type of responsibility to our children and that sort of thing, and get them to understand, look, we're going to get this law changed, but this is what we need to do as well. Parallel to this, we need to educate you. We need to prepare you. We need to, train you for that, so that you will be able to, stay away from that type of activity or being, sexually aroused at a particular age as opposed to another age and that sort of thing. So all I'm saying is that, and the very same thing, and I want to bring up the whole school violence back again into the conversation. And Kamala Prasad Misasa knew that she wanted to abolish corporal punishment in school. We should have started, sometime before that, to prepare ourselves to treat with the fallout of not having corporal punishment in school, develop different mechanisms and techniques to discipline children, and that should have been a part of teachers' training, I suppose. And we didn't do that. So all I'm saying is that it's like a business. You have a computer business, and you're bringing in the latest gadgets in the country, but you don't have the technician in the country to fix it when it goes bad. All right, it's something like that. Or you don't have the parts to service it when a part goes bad, but you have the latest gadgets. So all I'm saying is that in balancing this whole question of child marriage, we have to also look at these areas. And I'm not saying that I'm going to encourage people to marry off their children early and so on. What I am doing, and I've continued to do, is to encourage people to educate their children and to bring them up in an environment that is conducive to maintaining them, keeping them pure and in a righteous state and all of that. And this is where the church comes into the picture, and other institutions, other NGOs and so on and so forth, in like fashion. And the government has to, support these different institutions in developing programs in order to treat with this type of fallout.
I think the horse has bolted the stable, right? We're not gonna change. We're not gonna remove that age of majority from 18 to any lesser figure. Are you of the view that sex education in the schools, or sex education as a subject, ought to be introduced at the secondary level or the primary level, that would facilitate and assist young people in recognizing they have certain responsibilities that they to themselves in terms of how they conduct their sexuality?
Yes, I totally agree, but I also would also want to encourage that the religious groups be part of that program, that sex education in the schools, because you have to marry the both of them, the academic together with the religious doctrine as regards to that type of education.
Right.
So there's a lot of purpose for our religious institutions in our country, in Trinidad and Tobago, and for some reason they've been left out many times out of the discussion. They've never been invited. The most they'll invite the religious organizations to do is to say a prayer before you begin or deliberate your meetings or your functions and your events and all of that. And that's how we see the religious body here in Trinidad and Tobago. We have never seen them as a viable group of people that we can engage real conversation with and influence policy by engaging conversation with these religious organizations and religious groups. And I think more attention must be put towards that in moving forward.
Within recent times, there has been a lot of editorial things were said in the public space. We've had all this information arising out of the SABGA report about the abuse of children in foster homes, in residences, state residences. It is clear that as it relates to children, the religious organizations alluded to the fact that while you're complaining about us marrying children or encouraging child marriages or marriage amongst persons who are under the age or under a certain age, under the age of majority, the state itself wasn't doing what it's supposed to do to protect children in its own agencies. So there's a certain level, there's a perception that there's a hypocrisy among the politicians that they're pandering to adjusting the age, removing the power of the church to treat with its following in a certain manner, but yet still they're not doing what they could for the children generally in the country. What were some of the suggestions, or what is your position as it relates to the violence in the society as it relates to children on children, school violence, or your position as it relates to the state in treating with that? What do you think could be done, right, to deal with that level of school violence that we're facing on a day-to-day basis?
Well, again, I would have to put a lot of responsibility on the churches and religious groups. In every community in Trinidad and Tobago, you drive through a town, a city, a village, you'll see a mosque, you'll see more than one masjids, churches, temples, and all these institutions, they have membership. And the membership form part of the community. They're from the community. So the church does have a lot of influence on the society through their membership. And all I'm saying is that government needs to put more attention on these institutions and get these institutions, get the pastors, the imams, the pundits to do more in their community than what they're doing. Because I've always advocated within the Muslim community that in every masjid, there's supposed to be an outreach committee that actually interacts with the community itself, rather than just, within the walls of the masjid and so on. So you'll have, a general shura council, as we call it, or management council in the masjid, but there should be a subcommittee that is responsible for outreach and engage in the community, engage in the youths in the community, not just Muslims, non-Muslims as well, getting themselves involved in programs that at the community level, getting themselves in the events that the community may have from time to time, getting themselves a seat around the community in the community center, in the community board, or the whatever board there is in the community that regulates the activities of that particular community and so on. And so the religious society, the religious communities would have a greater say and a greater input in influencing policy across the board. And I don't think that we should spare. And I never advocated that. As a matter of fact, when I learned that the government was handing out funds, monies for masjids to celebrate Eid, I am one that is against that. I am saying that you should take that money and encourage that same institution to bring to the table programs that is able to make a change in the community and bring people away from that criminal type of lifestyle and so on, and that that negative lifestyle, right? And let's see what programs you have in place, and let's see how these programs are working. We want to see workable programs, and then we're going to pump some money into it. Let's see what successes you're able to bring towards the table. And government now should take that same money that they're giving these masjids to celebrate Eid. We can celebrate Eid on our own. We have enough resources to celebrate Eid, and we have been doing it for years. The government handing you this money to celebrate Eid, it's very, very suspect, in my view. So all I'm saying is that bring workable programs to the table where we can see that you're actually making a difference in the community in which you operate. Instead, we have a number of masjids in our communities, and I'm speaking from an Islamic standpoint here, that are virtually white elephants. It's like they don't exist. People would pass the masjid straight. The masjid is supposed to be a hub where people in the village and people anywhere could come in and go in and get advice and get guidance and all these things. There must be programs that should involve non-Muslims so that they can attend the masjid sessions and the masjid events and so on. And this is the kind of involvement that I think should resonate in the government's attempt to engage society in helping to change the way we bring our youth up in our communities. We often hear this saying, it takes a village to raise a child. Well, let's bring that back. Let us reestablish that back into our communities and our village and our societies. We need to do that because we often say it, but we don't do it. And there has to be some pivotal point where this must take place, this must happen. There has to be some, robust attempt.
Is it that you're suggesting that the government work closer with the church in order to train our young people, in order to align values, in order to encourage them to enjoy their childhood and their youth and not engage in activity? In this case, we're talking sexuality, to engage in activity that is unbecoming of their age? That there should be a closer relationship between the church and the state?
Yes, there has to be. There has to be. There can't be a separation, right? Because as it is right now, there's a separation, state and the church. We've seen that happen in the United States of America, where they've taken religion out of the schools. And look where it has taken United States of America. Every so often there's some massacre in some school somewhere in America because there's no guidance for young people.
Your view is that the lack of consultation between the state and the religious organization was even reflected in the removal, in the unilateral removal of the age of majority from what it was to the age of 18, meaning that there was no consultation as such with the church generally. That's all. The state took that decision upon themselves.
Yes.
And the fallout, right? And the fallout of that, is it that you're going so far to say the fallout of that means that the church is now left, the church and the family is now left with coping with the fallout from the change of that age, with coping with the fallout on their own without any government assistance?
That's exactly what is happening. You know much families that I'm aware of where girl children under that age got pregnant, and the families now have to face the very relevant question: what do we do at this point in time? How are we going to manage this whole affair? We don't want the girl to get an abortion. In some practices, you find that the families are vehemently opposed to abortion. They would want the girl to have the child. Depending on the stage of the pregnancy as well, it's difficult to abort a baby at that particular time. It may bring an adverse health risk to the mother and the child, etc., etc. All these things we have to look at. And the responsibility of the young man who would have impregnated the young lady, how the families are going to cope. And yes, there's the issue. They wanted to get married. We both agree that they're going to get married. Now there's a child out of wedlock. All right. So how are we going to treat with that? Government didn't give us the answers. That's what I'm saying. There are situations where some families would have, got the persons married and all of that. And, it doesn't have to be reported. And then they would get away with it once it's kept under a particular type of secrecy and so on. And that's what I'm saying. And what it is we're doing now, you've opened a doorway now for ways and means for persons to circumvent the laws of the country and to find themselves in more difficulty. Because if it would be discovered by the state that this is what happened, then this jail term the boy may be facing and the girl may be, or the family members may be facing, and that would put a severe sort of problems on the family at that point in time, financially and otherwise. Now you'll have the father of the child locked up in prison and all these things. All right.
Yes.
So all I'm saying is that we need to fix before. We need to fix before we fix. That kind of scenario.
Allow me to say this. I read recently where the United Nations at the 4th General Assembly in 2020, and I'm quoting here, it says that the Ministers of Foreign Affairs and International Relations of Canada describe child, early, and forced marriage as an abuse of human rights and as a major obstacle to the fulfillment of our women and girls' potential. So the United Nations position is contrary. I mean, they're mindful of the things that you say. There is strength and substance to some of the things that you're saying. But we have what we say, what we're discussing here impinges on what the United Nations is saying. They're saying that it's an abuse of persons' human rights, and the persons here would be the children. It's an abuse of their human right and an obstacle to their fulfillment and development as persons and individuals to encourage them to marry at a certain age, to encourage them to engage in activity that is really becoming of adults rather than children. So where there may be substance in some of the things that you say, I don't think you're taking into perspective or taking on board that the United Nations and supranational agencies don't share your view. Recently, Camille Robinson-Regis, locally here, she says she's of the belief that child marriage is child abuse in itself. So in as much as you may see it as a formula for dealing with, I don't want to use the word promiscuous children, but children who are sexually oriented or sufficiently sensitized to their sexuality that they want to engage in certain things. She is saying that to try to encourage marriage as a tool and as a mechanism to solve that in itself is amongst the child abuse. So some of the things you have said in terms of the marriage of the state and the religious organization, that marriage between state and church could serve as a mechanism to put policy in place to help deal with young people. Marriage of a different kind, child marriages, is not going to solve that.
I
Do
agree,
you
and
see?
the point about it is here. So we can actually say that the United Nations is okay with young children under the age of consent to having sex, because they have not put anything in place to treat with that. So what I'm saying is that let's not be biased here. Let's not be hypocritical, right? And because you want to sway in a particular direction because you feel this is what human rights is all about. But what about the right of the child, the unborn baby, that is in the womb of a 14-year-old girl impregnated by a 16-year-old boy, whose rights are being violated when a situation like that occurs, and you cannot get married because of the laws of the country, and so on and so forth. All I'm saying is that instead of changing the law, there are situations where there can be a compromise, where in extreme cases, right, this could be allowed under the pretext of religion. Because in an Islamically, a man and a woman can get married without going to the warden office or without signing the marriage registry, right? They call it a nikah, and that's the marriage that's recognized by Almighty God. So it's done in a place, in a space where there are witnesses, where there is an acceptance and a proposal and an acceptance and a dowry that, mind you, in the Islamic religion, that is demanded, that the woman demands. So if the woman says that she wants a house for her dowry, she has to be given a house. All right. So that is how the marriage in Islam takes place. And I guess within the Hindu religion and the Christian faith, it's about the same, right? The the act of actually going and putting your name on the registry is to legalize according to the law of the land and the constitution of the land. But our country does recognize common law marriages, which is what the Muslim marriages would be recognized as. And we have Muslim men in our society taking more than one wife. They'll register, they probably would have registered or gone on the registry with one, and they would have 2 wives, 3 wives, and the other wives will just be a nikah arrangement. And that is acceptable in our society. So what I'm saying is that there has to be a give and take. And we have to recognize the religious aspect of, in the first place, of why we would want to marry off our children at that age. And you cannot take that away from a family. You cannot take that away from a society that wants to protect their girls.
I guess it may be the part of the area that he's in now.
Yeah.
Because he's been driving along.
We are at a good point.
Yeah.
I know we're nearing the conclusion. He is saying that there ought to be some sort of compromise. There ought to be instances, exceptions to the rule. But I don't think Umar is saying that there's a hypocrisy in the society. We recognize the Muslim right to nikah and marriages that are not registered in terms of a civil manner. The state recognizes that exists, and they haven't made any attempts to stop that. The unregistered marriages that are only blessed by the church.
Under that nikah arrangement that Mr. Abdullah spoke of, the wife would have to be 18 and over still, right? That
Yes.
the state is recognizing.
Yeah, but he's saying that all the hypocrisy is that we recognize that.
I get that. Yeah, in other words, we know that the state is aware of that.
Yeah.
And yet still they don't have a problem with that. But in instances where you may need to have a compromise, like where he spoke about the 16-year-old male and the 14-year-old girl with a child in her womb, and yet still they would not allow a compromise, for that situation to be rectified in the best possible way, which is to allow them
so he's
to be
looking at
married.
special circumstances.
Yeah. So he said in the same way you could accept a Muslim person going to register one of his, but then have 2 others on the side. And the state is aware of that and have no problem. There could be an exception for certain circumstances, such as the one you described with the 16-year-old and the 14-year-old girl.
And this is where the responsibility of the church comes in. The responsibility of the church is to manage that affair in a manner in which that the government, we can even bring it to that level, that the government is satisfied. We are satisfied that this organization is a responsible organization, and they would ensure that right be done by the young girl. She could continue her education. And these are some of the questions that do arise when we discuss marrying off our girl children at any age, as a matter of fact. And I would have had conversations with my wife many times, considering our daughters and so on. And the position is, our daughter needs to be educated. She needs to go to school. She needs to get a job. She needs to be independent, etc., etc. And we should not get her married before that, etc. But at the same point in time, we have to manage that relationship that she would have, or she would may develop, or may probably extend towards a boy. You understand? And we would have to, properly manage that in a way that it does not go south. And this is exactly what I'm saying, that there has not been enough engagement by the state with the church in aspects like these. And we can talk about, violence and criminal activity and all the rest too as well. All of that would be more or less brought down to a very low figure in our country if only the church are allowed to intervene in these policy making of the government.
Umar, I want to thank you for your presence and for sharing your frank views. On some levels, we understand where you're going and where you're taking the argument and the discussion. My position is we're putting a lot of blame on the state and our parliamentarians, but what we need to bear in mind is that they have pressure. They are feeling the force and the weight of international agencies, the United Nations,
that they brought on themselves.
supranational forces that are guiding us on our minds and the minds of the state and the hand of the state in a particular direction. And our argument here might appear to be at the very end of the day very circular, because we may have come full circle in terms of understanding where things were historically and where things were culturally years ago and where we are now, and the pros of yesteryear as opposed to the cons of our current social structure. But we can't escape the fact that the United Nations rule the world, and international agencies determine how government policies are shaped and formed. And our social policy is being influenced by a hand that is outside of Trinidad and Tobago. So our development, and we could say this, Richard, you're free to correct me, this is my view. Our development is hinged on how we manage our children and how we manage our young people, and how we direct their minds and their thoughts. And any fallout of that is a social issue that has to be dealt with in the home. We can't depend on the state.
And the how we manage there would include the spiritual link that we must have our children exposed to make sure that they understand God and how important that is in their lives to help them move forward. Yeah, once you add that to what you say, we're on the same page, Farid.
Yeah, certainly. Yep. Richard, we're getting to that time. We are 7 o'clock. I
know we had this lady came on a little early on, but we weren't able to have her participate. I don't know if you had recognized her.
No, my discussion with our producer was that she was attempting to, but she couldn't link. But
oh, she came on for a brief time and then.
She couldn't connect with us because she had a meeting. She had a meeting.
Oh, I see.
So we couldn't incorporate her. She couldn't stay with us.
Perhaps next time then. Okay. Could it have been nice to have views along Mr. Abdullah's views? Yeah. Perhaps next time.
So we've had another vibrant discussion, Richard. I think that we're covering some ground. We've touched on some social issues. But I'm very.
Abdullah, one thing before you run, I know you're probably close to his destination now. With all the school violence and so on with children, what is your take on that, Mr. Abdullah? What is happening?
There's a number of things that would have come to my attention, and we are looking at it very closely in detail before we make any pronouncement on it. But we feel part of the problem that exists now in the schools was as a result of a fallout from the lockdown that we experienced over the past 2 years. There was a lot of anxiety, a lot of uncertainty that existed within the home. We had situations where family circles already were a volatile situation, and locking them in together in one unit within 4 walls exacerbated a lot of the problems that we have and we see happening. A lot of frustration by the parents not paying particular attention to their children and listening to their children, hearing their children, their concerns that the children may have, and so on and so forth. Some parents have an attitude where, whatever they say goes, and, whatever you say does not count, etc. Things like that. And we would have seen psychologically it's affecting a lot of the children. And going back out to school, putting them in an environment where there are others, you know, having that ability to communicate with a mask on their face, keep that in mind, a mask on their face, which is an inhibition in our view, because it prevents a child from communicating properly. It prevents a child from speaking properly. It sometimes creates a sort of intimidation. Before COVID, you wear a mask and go into a store, you get arrested. Now you'll be given a ticket if you don't wear a mask. All right, and this is the dynamics of that has changed our society and plummet us in a situation where we have lost grip. We have lost that grip of control on our youth, our young children, and we are grappling in the dark, trying to figure out where the mind of the young child and where they are at, and what are their issues and what needs to be addressed. And we're not listening to the children. And I think there has to be some sessions in our school system now, more than ever, where teachers should engage our children and get a sense of response from them as to what they feel, what they believe should be happening, you know, and let them be part of the process of that growth and development rather than hand down to them what has always been there. So I think now children needs to be part of the planning, part of the process, part of the you know, the development, and we must give the children now a chance to speak and a chance to express their ideas and their logic so that we could better understand them and better provide for them and better facilitate them in whichever aspect they find themselves in.
Thank you so much. And we hope that when you'll get together and you put out the final piece that you're working on, it would be quite helpful to anticipate and imagine, and we'll comment on it thereafter. But I agree with you. Part of it could be that it may have been unspent energy built up over the COVID period that is now gushing out from those youngsters and have them behaving as they are. So that could be a big part of the problem. I didn't see it as such, but it's something now that one
there should have been an orientation.
Yeah, there should have been an orientation back to school.
There should have been an orientation. That's every school. Yes, in every school there should have been an orientation, a special orientation. I think that would have helped. Yeah.
And even now that they're back out to school, they are limited with the physical classes that they could take, what we call PE back then, physical education. Yeah. Still has some limits on it.
Yeah, because so a lot of the schools, they're not being allowed to go out and play. They're not being allowed to go out.
Yeah, so the energy is still locked up in them. Yeah. And now in school, so the smallest of things could cause such a huge overreaction, you know? So it's really something else. It has to be studied. It has to be studied. We'll wait on all the final production of what you all are considering now in relation to this as a group. And surely I'm confident that it will be able to help us to move forward. So I'd let your friend, and you are my friend too, but I know you're a very close friend, Farid. How should I say, why not the interview? Farid.
Umar, thanks for making yourself available to us. I think we're having very fruitful discussions. Yeah, we're having very fruitful discussions, and hopefully we can have more of this on a wider scale, incorporating the other religious bodies in terms of hearing what their position is. But one thing we can say is that parents need to get more involved in the lives of their children, and the state needs to understand that more support needs to be given generally to the religious organization and more consultation when they're making decisions. But like I said before, the horse has bolted the stable. We're not going to have any reversion to a lower age, but hopefully we'll have more education moving forward and more proactivity between the families, the church, and the state. So thank you again for your contribution, and we look forward to for future collaboration.
Yes, and again, thank you for having me, and you know, do enjoy the rest of the night, Richard and Farid.
Thank
Yes.
you so much,
Be
and
safe on
same
the
to
road.
you.
All right,
Same
take
to
care,
you,
bye.
Mr. Umar Abdullah. Yeah, okay. Well, Farid, it was another entertaining and, how should I say, day of solid information. We may have helped a lot of our